case briefs, and so much more. LSData's got what you're looking for.
In 2005, a heated dispute between two corporations, Examen and VantagePoint, sparked a significant legal showdown that reached the Delaware Supreme Court. The disagreement stemmed from a proposed merger and the voting rights of a preferred shareholder within that context. VantagePoint, arguing its case, insisted that California law should govern the vote, a law that would necessitate separate class voting for shareholders. However, this contention faced opposition from Examen, who insisted that Delaware law, which requires a majority vote of all shareholders as a single class, should govern the merger. The Court of Chancery initially handled the case, delving into the intricacies of the internal affairs doctrine, a principle that posits that only the state of incorporation can regulate a corporation's internal affairs. Following careful consideration, the Court of Chancery sided with Examen, ruling that the proposed merger vote should indeed be regulated by Delaware law. Undeterred, VantagePoint appealed this ruling, sending the case upwards to the Delaware Supreme Court. This resulted in an intense examination of the internal affairs doctrine, the principles at stake, and the rights and roles of the preferred shareholder. Despite VantagePoint's unwavering arguments in favor of applying California law, the Supreme Court stood its ground and upheld the lower court's decision. Emphasizing the internal affairs doctrine, the Supreme Court held that voting rights in a merger between two Delaware firms are indeed governed by Delaware law, which necessitates a majority vote from all shareholders as a single unit. The decision underscored the point that a corporation's internal dealings and affairs are under the jurisdiction of its state of incorporation, lending legal weight to this age-old principle.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.